Hello viewers, this is attorney Naresh Gehi and we are going to talk about the unlawful presence waiver. What is it and what happens and what do you need to know about the unlawful presence waiver? The unlawful presence waiver is also known as the provisional waiver, which means, take an example that you are living in America today and you're an Indian national, and at this time you entered into the United States by crossing the border. And now, under Section 245A of the INA, you're not allowed to get an adjustment of status in the US because you crossed the border and you came to the country. So now, what happens in these cases if you're not grandfathered under Section 245I, which means if you did not have a petition pending before April 30th, 2001, what you will have to do is that your US citizen relative will have to sponsor you for the green card, and after the I-130 petition is approved, then the case goes to the National Visa Center, and after that the case goes to the consulate. So if you are in the US, in this instance, you can consider filing for the unlawful presence waiver, commonly referred to as the I-601A waiver. And how does the 601A waiver work? Real simple. You cross the border from Mexico, you came to America. And then after that, either your parents have sponsored you, who are citizens, or your spouse, who's a citizen or a green card holder, has sponsored you. And now you're in America. So the good news is that what happens in these cases is your I-130 has to be approved first. After that, exactly, your National Visa Center processing has to be done. And after the National Visa Center processing is completed, you can start working on the 601A waiver concurrently. So while this is in progress, when the case goes to the consulate, and if your 601A waiver is approved, then you can travel abroad after the approval. So what you did, you continued to stay in the US until your 601A waiver is approved. Now what happens if the waiver does not get approved? You apply again. And if you apply again, then in this instance, once it's approved, then you can show up before the consulate and you will not be subjected to the 3-year or the 10-year bar because your 601A waiver was approved. And what I would do in this example, take an example, you crossed the border from Mexico, came to America, you married someone or your parents sponsored you, and after that your priority date became current, and you're worried that should I go back to India? You should not be worried, especially because if you don't have any other adverse factors in the case, you should not get very much worried. So what do? Get the papers approved. After that, you file your case with the National Visa Center. Then after that, your matter comes back before the consulate. And if the case is approved, you will have to show up before the US consulate. And once if they stamp your passport, you can fly back to the United States as a permanent resident of America.